Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a new piece of federal legislation, Bill C-9, the Combating Hate Act. I had the privilege of appearing at parliamentary committee on this proposed new law, where I outlined some of my concerns. The law would result in more investigations, charges, prosecutions, and convictions for speech, including online speech, that the government deems hateful. Now, I want to be very clear. Hate is wrong and it causes real harm in society. Hateful conduct, especially violence and threats, must be confronted. But criminal law is our most powerful state tool, and it carries the highest stigma and most serious consequences for liberty. It must be used with restraint, especially in matters touching expression, belief, and political and religious discourse. I believe that Bill C-9 expands the criminal law into the realm of expression in ways that risk unjustified violations of the Charter right to free expression. It lowers existing constitutional thresholds, removes safeguards against politicized or abusive prosecutions, introduces vague new offenses, and risks chilling lawful debate and protests. That's what I said at committee. Now, here today are two experts who also presented at committee on this bill. Derek Ross from the Christian Legal Fellowship, and Anaïs Bussières McNicoll from the Canadian Civil Liberties Association. Thank you both so much for joining me today. Now, I think we all share the same concerns about the rise of hate in Canada, but I'm very concerned about that issue, but I also want to ensure that what we do to address hate is constitutional and that it actually works. And right now, Canada does have prohibitions against hate propaganda offenses in Section 319 of the Criminal Code. And Ais, maybe you could tell me about what the law already says right now before C9 enters the picture.
Absolutely. So the criminal code prohibits public incitement of hatred, which means publicly inciting hatred against an identifiable group in a way that is likely to lead to a breach of the peace. The criminal code also prohibits willful promotion of hatred, which means making a statement other than in a private conversation, in which one promotes hatred against an identifiable group. The notion of hatred has been defined by the Supreme Court of Canada as an emotion of an intense and extreme nature that is clearly associated with vilification and detestation. So what that means, and the Supreme Court of Canada was clear to that effect, is that expression that merely offends, hurts, or humiliates is not hate speech. So the bar is quite high.
Yeah, and I think one of the concerns that I have, and I think both of you share, is that C9 might be lowering the threshold for what constitutes hate. We have that definition of hatred that you just gave, Anais, that comes from the case law, specifically from the cases of Keegstra and Whatcott. But what Bill C9 does is it proposes a new definition. Derek, maybe you could tell me a little bit about what's being proposed and why it might actually be lowering the threshold for what constitutes hate.
For sure, Christine. And just want to reiterate your point. When we express concerns with a law like Bill C-9, it's not because we disagree with its intent. It's precisely the opposite. It's because the combat of hatred is so important that we want to ensure that these efforts are both effective and constitutionally sound. And that is a concern with this new definition of hatred that is being introduced into the bill, is it's missing some of that language that my colleague just mentioned. It doesn't make reference to extreme manifestations. It doesn't use the word of intensity. It refers to the emotion of vilification and detestation. And without some of those added prescriptions from the Supreme Court, such as extreme manifestation and intensity, um, without that language and other prescriptions, the concern is that the focus now may be lower, that the focus is more on the emotion, perhaps the accused's emotional state of mind. The focus on emotion also raises concerns about subjective interpretations, focusing more on the feelings of the accused or the feelings of a complainant, and particularly not focusing on the effects of the expression, which the court has said we must focus on. What are the effects of the expression, not necessarily its content?
Yeah, I mean, the idea of willful promotion of hatred includes an element of causing another person to have this feeling. It's not just about your own internal subjective mental state. It's the intent requirement, the mens rea requirement to cause this in other people. this seems to become a little more blurred with this definition, as well as just removing some of that qualifying language. We've got to go to break right now, but we'll be right back.